I call Ian McKelvey.
Thank you, Mr. Speaker. Just before I get on to the facts of the night, I thought I was mentioning a couple of other things. Firstly, I guess that I wanted to pay tribute to Celia Lashley. I had a lot to do with her in my time with the Mayor's Task Force for Jobs, and she was an amazing person who had an amazing way with young people and certainly played a large part in the very topic we're talking about here tonight in respect of our law and order community. So that was the first thing I wanted to talk about. The second thing was the fact that Chris Gale just hit 200 in a World Cup game, first time it's ever been done. I think that's pretty significant given that the World Cup are very topical at the moment. So I thought that was quite important. Right on to the parole amendment bill, and I wanted to talk, you can only talk about so much fact in one of these things, and so I needed to talk about a few other things. And during the course of this, the early discussions on this bill, of which Mr. Farfoy, interestingly, was part of the early discussions of this bill, on this bill. He was a member of the Select Committee when it was introduced, I would imagine. But I wanted to talk about the structure of the parole board and how that works, and then I wanted to get on to one or two other things that we found during the course of the investigations into this bill. But the parole board, and we had the opportunity early in the piece with this bill to visit a parole hearing. And I was fortunate enough to go to Wanganui, where I attended the parole hearing of one of our most notorious, parolees, and it was a really interesting process. And you get to see how the process works. So there's 3 people on the parole board. There's a convener and 2 others, and they bring the prisoner into the parole hearing. They present the evidence. The prisoner can have a representative with them. They can have a lawyer with them. They may choose to be there on their own, and certainly the whole process for mine was very impressive. And I think that to see how the parole system worked, it made a big difference to the understanding of how this whole bill proceeds. And so that was the first thing we found out. The second thing we found out was that the parole board doesn't necessarily have access to all the information that we felt it needed. And it certainly didn't have access necessarily to any protection orders that had been given to those prisoners who are appearing before the parole board. We felt that was necessary, and our understanding now is that the Judicature Amendment Bill, or the Judicature whatever bill it is that's coming into the House in the next, right now in fact, will take care of some of that issue, because it was a significant process. And so prisoners were going into these parole hearings, and at times the parole board didn't necessarily have all the information that gave them the background on that prisoner. So that was a bit of a challenge, we felt, for the parole board, and we made some inquiries into that, and I think have now got to a point where we're satisfied that it creates an environment where the parole boards can operate fairly. There are, as Jonathan Young said, he had an average of some 5,000 parole hearings. In fact, there were over 6,000 parole hearings in the last year we had statistics for. That's a lot of parole hearings. This bill will relieve us of about 800 of those parole hearings, and to appease New Zealand First, who are always wanting to put more money into everything, that will save us about $700,000 in the parole board's operational costs. And I think aside from the fact that it's saving money, it's creating a whole lot of, it's easing the situation, firstly for victims, because they get notified as a parole hearing comes up, so there'll be 800 less notifications of victims a year if you look at it from that, kick the bucket from that perspective, and so that will make quite that will make quite a lot of difference to the. Now I've lost my concentration as well, Mr. Speaker. But so having the saving of that money will make quite a bit, of the information that needs to come to those parole hearings will make a difference to the victims. It will also make a difference to those prisoners who are constantly dragged before parole hearings, at least on an annual basis, sometimes end up with up to 4 or 5 parole hearings. In fact, I think the average may be 4 parole hearings before they are released. So that will alleviate that problem quite a bit too, so probably take at least 2 hearings out of that. So I think that there are some really good features of this bill, and whilst this bill only affects although I guess 6,000 parole hearings, it's really only probably affecting 1,000 odd people a year, so it's a very small part of New Zealand's overall well-being. it does nonetheless have a positive effect on all of those victims, and certainly on those people who come before the parole board. So there's a whole lot of other things that came up as part of this, and the select committee, I think we considered some 12 submissions in the course of this bill, almost all of them positive, some of them pointing out, as they always do, some of the pitfalls that you find with this kind of, I guess, with this kind of legislation, and obviously human rights becomes a factor, and all these sort of things like that become a factor, and you get these submissions on those lines. But on the whole, the submissions were positive and supported the bill. So I think it came out pretty well from that perspective. So there's some other things that the bill created. So this bill, interestingly, was introduced in 2002 initially by the Honourable Phil Goff, who interestingly was on that select committee as well. Just shows you can be here for a long, long time and you get to change the bills you started with. But he certainly achieved that on a number of occasions. So the bill requires that when the parole board declines a parole application, it sets the next hearing date. And so that gets set, and the conditions on which those parolees or the people who it applies to have, they get set a set of conditions which they must, I guess, comply with. So they've either got to go through some kind of alcohol and drug program, or they have to come back with some form of employment as they leave prison. They may have to come back with accommodation that they can go to when they leave prison. There's a lot of things that they can be required to bring back to the next parole hearing. And if, of course, the offender achieves these early, the case can be brought forward. So as I said earlier, it provides that a victim that a victim, offender or other authorised person can attend a parole hearing remotely, such as via video link or phone. I certainly haven't seen that in action, and the parole hearings we attended were all right there. The bill also provides that as well as the victim, prison managers and police must be notified of hearing outcomes. They are also to be notified of the next parole hearing date and any milestones, and as I said earlier, any milestones the offender has had set for them. So there's some conditions that make the thing much sounder than it was before. So I think we're getting along pretty well with a lot of the changes to this bill, and the board, after the initial appearance, must consider the prisoner for parole at least once every 12 months. So that's what happens now, as I said. And so once that's happened every 12 months, they come up, and once the conditions are imposed, they'll then be, I guess, the parole board will make a decision as to when they come back before the board for the hearing. So Gail's 220 now. He'll get there shortly. So, Mr. Speaker, it was a very interesting bill to be a part of, and I think that during the course of it we did turn up some information that was well worth discovering, and certainly it helped us to get through and come up with what I think is a very good conclusion. So Mr. Speaker, I have a great deal of pleasure in supporting this bill as it goes through the House, and we very soon will be through the House. Thank you.